Hi everyone, let's talk about genuineness of assent and undue influence. In this lesson, we'll examine unilateral and mutual mistake, identify the elements of fraud and its various types, define and examine duress, and define and analyze the equitable doctrine of undue influence. So to get started, we realize that mutual assent is one of these elements of a contract. Mutual assent basically means the meeting of the minds. It's when both parties understand and agree to be bound to the terms of the contract. Mutual assent has to be genuine, meaning that the parties' assent to the contract be genuine in its nature. If something about the contract destroys mutual assent, it is called a defective agreement, and the law could permit rescission. So what can go wrong with mutual assent? We'll talk about four main things here. So mutual mistake, fraud, duress, and undue influence are the main topics we'll be discussing. A mistake is just what it sounds like. It's when somebody has an erroneous belief about either the subject matter, the value, or some other aspect of the contract. The law permits rescission of some contracts where there's a mistake made. Rescission is the undoing of a contract, allowing somebody to rescind their responsibilities under that contract. So first, let's look at a unilateral mistake. This is when only one party is mistaken about a material fact regarding the subject matter of a contract. In these cases, where it's only one party being mistaken, the contract is generally still enforceable. There are some exceptions, though, as it seems there are with almost every legal principle. The situations where a contract might not be enforced due to a unilateral mistake are when one party makes a unilateral mistake of fact and the other party knew or at least should have known that a mistake was made, or when a unilateral mistake occurs because of a clerical or mathematical error that is not the result of gross negligence. We see this sometimes if you order something online because it looks insanely cheap only to have that website then cancel your order due to a price mistake. It happens all the time. And then finally, the mistake is so serious that enforcing the contract would be unconscionable. A mutual mistake is when both parties, or all parties involved, are making a mistake about some material fact important to the subject matter of a contract. In these cases, either party could rescind the contract. We define material fact as being something that is important to the subject matter of a contract. These are the who, what, when, where type terms of a contract. Examples of mutual mistake include mistake as to the description of the subject matter, mistake as to the existence of subject matter, if it gets, for example, destroyed somewhere along the way, and ambiguity, meaning we could interpret a word of the contract in multiple ways, and if we can't come to terms on what we actually mean by that term, then we would say it's too ambiguous and the court wouldn't enforce it. So an example, this is a classic case talked about in law classes everywhere, but Raffles versus Wickelhaus. This happened in 1864. It comes from English common law. But the basic idea is that we have two parties, Raffles and Wickelhaus, who entered into a contract for the sale of bales of cotton. The cotton was to transport on the ship named Peerless, departing from Bombay and arriving in Liverpool. What the parties didn't know is that there were actually two ships named Peerless that departed from Bombay and arrived in Liverpool. One was set to arrive in October, and the other one was set to arrive in December. So the defendant shows up in October expecting the delivery of cotton. It doesn't come. He assumes the plaintiff just fell through. The plaintiff shows up in December expecting to sell the load of cotton, but the defendant refuses to buy, saying that the contract is not enforceable because of a mutual mistake. So the plaintiff then sues for breach of contract. What the court eventually decided was that they ruled in favor of the defendant, saying that there was no meeting of the minds because the court couldn't determine which ship was actually intended in the contract. So it was too ambiguous and they wouldn't enforce it. What about when two parties make a mutual mistake about the value of something? Sometimes this happens if, with artwork or people that go around buying stuff out of antique stores because they think it's very valuable. Maybe either they think it's worthless and it turns out to be very valuable, or maybe they think it's very valuable and it turns out to be worthless. When the mistake is about value, the courts generally don't step in, saying, well, the court's not going to get involved in trying to assign value to items, so the courts will generally still enforce if it's a mutual mistake of value. So now let's look at fraud, called fraudulent misrepresentation, also called intentional misrepresentation. We're mostly going to abbreviate it to fraud just for the sake of ease of use. So a misrepresentation is when an assertion is made that is not in accord with the facts. In other words, it's a lie. Somebody is saying something that is not true. In fraudulent misrepresentation, abbreviated as fraud, one person consciously decides to induce another person to rely and act on a lie. The contract then becomes voidable by the innocent party. They can either rescind the contract and obtain restitution, aka their purchase price back, or they can choose to enforce the contract and then sue for damages later. So the elements of fraud, and we'll talk about each one of these in a little bit more detail. The first element is that the wrongdoer made a false representation of material fact. The wrongdoer intended to deceive the innocent party. The innocent party justifiably relied on the misrepresentation, and the innocent party was injured. So, like I said, let's talk about each one of those in a little bit of detail. So misrepresentation of a material fact. I can lie with my words or even by conduct sometimes. To be actionable as fraud, the misrepresentation must be of a past or existing material fact. So these material facts are the things that are actually very important to a contract. Who, what, when, where, how much, things like that. To establish intent to deceive, we have to prove that they intended to deceive the innocent party, meaning they either had knowledge that the representation was false or made the representation without sufficient knowledge of the truth. Next, the person has to have relied on the misrepresentation. To justify his, her, or her reliance, the basic stance of the courts is that we assume that they justifiably relied on it, unless we can somehow show that they knew the misrepresentation to be false. In other words, they knew the lie was a lie, or the lie was so extravagant and just so ridiculous as to be obviously false to a reasonable person. Then I couldn't claim to have justifiably relied on something that was, just too good to be true. We have to have injury to the innocent party, have to have suffered some type of loss. Monetary usually is what we're talking about. So I have to prove that that the fraud caused economic injury. And usually we can measure that economic injury in dollars. So the measure of damages is the difference between the value of the property as represented and the actual value of the property. So if I said it was worth $1 million, but it was only worth $500,000, the damages would be the difference, $500,000. The innocent party can either sue for damages, that difference, or they can rescind the contract and recover their purchase price. All of that predicated on whether or not we can actually find the person and get anything from them. Common fraudsters, it's probably not their first time, and they've probably figured out how to evade law enforcement and disappear to where you can't find them. A lot of fraudulent schemes are run from offshore phone numbers, offshore accounts, people in other countries that would be hard or impossible to track. So, if you fall for fraud, in those cases, you might just be out of money and with nothing to do about it unless you can track those people down. So we'll divide fraud up into two major categories, one being fraud in the inception and then the other being fraud in the inducement. So fraud in the inception is also known as fraud in the factum. A person is deceived as to the nature of their act and does not know what they are signing. This results in a void contract. So an example would be, I ask you to sign a petition to save the rainforest, but actually what it is a contract that would entitle me to possession of your car. So I'm lying about the entire nature of the contract in general, and you don't even know what you're signing. Of course, you would want to read that, but a fraudster could perhaps take my signature off of the petition and then forge it onto another kind of contract. That would be fraud in the inception. Fraud in the inducement. So the innocent party would actually know what they're signing, but they've been fraudulently induced to enter into the contract. This would result in a voidable contract by the innocent party. They could void it if they wanted to, or they could enforce it if they wanted to. So an example would be, I ask you to invest $10,000 in my business to invent a better COVID vaccine, but I use the money instead to just pay myself a bonus and take a vacation, and just sort of abscond with your money. This kind of thing happens. So in this case, Park 100 investors versus CART. CART agreed, CARTs, well, I'll call them the CARTs, it's a couple. They agreed to lease space from Park 100 for a business they had an ownership in called KVC. A representative of Park 100 named Scannell shows up the night before KVC is supposed to move in, saying that they have lease papers to sign. The CARTs are in a hurry because they're trying to make their daughter's wedding, what do you call it, the night before the wedding, the rehearsal dinner. So they don't have time to sit down and read all the papers. They call their lawyer to make sure that signing lease papers would be okay. The lawyer says, sure, you can sign lease papers. But they weren't really lease papers in the sense that they understood them to be. It was actually a personal guarantee of the lease, meaning if KVC, the business, didn't pay, then they could hold the CARTs legally liable, and then they would have to make those lease payments. They had never discussed a personal guarantee before. This was something new that no party had talked about prior. The CARTs sign. After hearing their attorney say it was okay, they didn't actually read the papers. Later on, several years down the road, the CARTs sell their interest in KVC to somebody else. The new owners of KVC stop making rent payments, so Park 100 sues the CARTs, who were quite surprised to hear about this lawsuit. The court said, while the general rule is a person is bound by their signature and is responsible for reading the contract, they won't be bound if the signature is procured by fraud. So they thought that him lying about the nature of the contract they were signing was fraudulent, or at least fraudulent enough to where the court wouldn't enforce it. Another case, and I'm going to butcher these names because I'm bad at pronunciation of Spanish names, but I'm going to take a stab at Portuguese Santana versus Recomdiv. So Portuguese wants to open a Victoria's Secret franchise in Puerto Rico. They enlist the help of Domingo, a business broker. I'm just abbreviating these people P and D just because it saves lettering and it was getting kind of ridiculous. So Domingo tells Portuguese that it's a done deal if he hires his firm. Domingo's firm is Recomdiv, and a law firm, Venable. So Portuguese agrees. He pays retainers to both firms totaling $625,000, assuming they're going to get this franchise open for him. So months go by. Venable finally contacts Portuguese saying Victoria's Secret doesn't actually do franchises. Corporate owns all of its own stores and operates them, so no franchise can be opened. So Portuguese sues Domingo. Domingo's company Recomdiv sues Venable and Bay, who was Venable's owner. Venable and Bay were smart enough to settle out of court for some undisclosed sum of money. The case proceeds against Domingo in a U.S. court in Puerto Rico. So the issue at hand was, are Domingo and Recomdiv liable to Portuguese for the Spanish word dolo, which means fraud? And I thought I put the conclusion there, but okay, I'll just tell you what happened. The court thought that, or ultimately decided that yes, they were liable for fraud, and they had to pay back the total $625,000 to Portuguese. Okay, so more types of fraud. We could have fraud by concealment, which is maybe I don't say something that is a lie, but I've taken action to conceal some material fact from another party. Maybe there's something physically wrong with the subject matter and I just sort of paint over it and hope they don't notice. Or maybe there are some financial records that would be damaging and I shred those to make sure nobody sees them. So concealing some material fact from another party. We could also consider the case of silence as misrepresentation. So concealment is actively concealing something that I would have some kind of duty to disclose. But that doesn't mean that either party has to disclose every single fact to the other party. So silence isn't always going to be misrepresentation. In fact, generally, silence is not misrepresentation unless non-disclosure would cause bodily injury or death. So courts don't look very fondly about people not disclosing things that could be very dangerous. Or if there's a fiduciary relationship between the contracting parties. Fiduciary relationship, fiduciary breaks down to trust relationship. So this is usually like attorney-client, or more common with these contracts, a board member for the company who's supposed to be acting their best interest. But it's a special kind of relationship where you have a higher duty to disclose certain things. And then finally, you might have a federal or state statute requiring kinds of disclosure. So using my house sale example again, but state law says that for houses that are ordered at a certain age, I think it's 1965 or something like that, if your house was built before that, you have to fill out a disclosure saying whether or not you have lead paint in your house. And you have to say either yes, I do have lead paint, or no, or saying just I don't know. So what about somebody says something about the law and that turns out to be wrong? This happens quite a bit because the law can be pretty complicated and it's easy to get things wrong. This is usually not actionable as fraud. The courts generally think that people should be aware of the law regarding some contract. You either should know it yourself or you should hire an attorney that can help you understand the law in that area. The big exception there being that if one party is a professional who definitely should know what the law is and they intentionally misrepresent the law to a less sophisticated party, that's somebody really just taking advantage of somebody else, and the courts are not going to look very fondly on that. Also, innocent misrepresentation. What about we say something that's false, but we didn't do it on purpose and we weren't trying to deceive anybody. I didn't know. So this is not considered to be fraud. This would just be maybe considered either to be a mistake or just a whoopsie. But the courts generally are still going to enforce the contract as long as they don't find that I was intentionally trying to deceive. So in the case Carissa versus Payne, we have a couple who are shopping for a truck at Payne's Car Company. They're looking for a truck that can haul their trailer. So a salesman shows them a Ford F-350. He tells them that it definitely would tow their trailer. He says the truck would last 400,000 miles. And he said it was a one-owner trade-in. So only one other person had ever owned that truck before. So they take a short test drive and they buy the truck and immediately start having major issues with this truck. Major to the point where it just wasn't operating at all. They later on obtained a Carfax report, which turned up and showed that the truck had in fact had 13 prior owners and was actually two halves of other trucks that had been welded together. They took it to a mechanic who was an auto expert, and he warned them that it was unsafe to operate this truck. The Crisa sue for fraudulent non-disclosure and fraudulent misrepresentation. The court finds that Payne acted indifferently to or in reckless disregard of the Crisa's safety in selling them the truck. The evidence in the case also supported a finding that the harm was the result of malice, trickery, or deceit, and was not merely an accident. In other words, it was not an innocent misrepresentation. It was very intentional. And when a court finds that there was this malice or trickery or deceit involved, that supports the awarding of not just compensatory damages, compensating them for the financial loss, but also punitive damages, which can be much higher. So the jury awarded $18,449 in compensatory damages, and then they tack on an extra $500,000 in punitive damages, designed to punish the car dealer for wrongdoing. And an appellate court actually upholds that verdict. So they got quite a bit of money out of that. So that's a warning against, intentionally deceiving your customers. Duress. Okay, I think we've talked about duress before, but duress is a situation in which one party threatens to do a wrongful act unless the other party enters into a contract. Classic case would be holding a gun to somebody's head and saying you have to sign this contract or I'll shoot you. Obviously most people are just going to go ahead and sign the contract because they don't want to be shot. So if the victim of the duress signs the contract, it's not enforceable. The court's not going to enforce that kind of thing. It doesn't always have to involve physical harm either. So threatening to commit extortion would be considered duress if somebody signed a contract. There have been, some cases recently where, somebody in the internet turns up some compromising photos of some public figure and they threaten to, put those all out on the internet unless they pay them, $1 million or something like that. Okay, so that's going to be extortion. Even if they had signed a contract saying, I'll pay you X amount of dollars, just please don't put the pictures out there, that wouldn't be enforceable. They wouldn't have to pay that money. So not only is the contract going to be void, but that person trying to extort them is probably going to get into some criminal trouble as well. So threatening to bring or to not drop a criminal case is also going to be considered duress. However, threatening to bring or not drop a civil case would not be unless the suit is considered to be frivolous or brought in bad faith. Here's an interesting question because we're dealing in the COVID-19 crisis right now, and we see some cases of these people who go out and hoard these, whether it be like toilet paper or hand sanitizer or medical masks or whatever it might be, and then they price gouge during the crisis. This could be potentially considered what we would call economic duress. Economic duress is putting somebody in a situation where even though they know what's going on is probably wrong, they just don't really see any other good options but to just go ahead and follow through with the contract, at least in that time. Now, looking back, once the dust settles a little bit, what we might see is a few lawsuits popping up here and there where somebody felt like they were forced to pay some price that was just way too high. They had no choice in the moment, but they might be able to turn around and get them for it later on. We've also seen some places where There are laws in place to prevent this type of behavior from happening, price gouging during a crisis. So there might be some actual criminal charges for some people as well. Not always, but there's a chance. Undue influence, another one of those things that can go wrong with mutual assent. It's when we'll have a dominant party and we'll have a servient party. The dominant party takes advantage of another person's mental, emotional, or physical weakness. That's the servient party, the weaker person, unduly persuading that person to enter into a contract. So the persuasion by the wrongdoer must overcome the free will of the innocent party. So we're talking about a relationship where there's a severe power imbalance between two people to the point where one person could just exert an extreme amount of influence over another person, causing them to do things they otherwise wouldn't do. So mere persuasion in and of itself is not undue influence. Influence gained by kindness and affection is not undue influence unless there's a lot more to it. We see these kind of cases pop up surrounding wills quite often, where somebody thinks they were written out of a will or didn't get as much as they thought they should have gotten out of it, or thought somebody's getting too much out of it, and they think that person must have unduly influenced the person who died. But it really kind of depends on the circumstances. So generally, the elements we have to show to prove undue influence are we had a fiduciary or confidential relationship that existed between the parties. That would be examples of fiduciary relationships are attorney-client, doctor-patient, guardian-ward, trustee-beneficiary, or board of directors to a corporation. Those are examples of undue influence. We see it most commonly with elderly people, but it can happen in other cases too. The dominant party must have unduly used his or her influence to persuade the servient party to enter into a contract. So that's sort of generally nationwide, but let's look at North Carolina specifically on the topic of wills. So for challenging a will, an undue influence occurs when a person's professed act is not their own, but is in fact the act of the person exerting the influence, causing the servient party to make a will they would not have otherwise made. So some factors that courts in North Carolina will consider when analyzing whether or not undue influence has happened are the age of the person, their physical condition, their mental condition, what was the relationship of the parties, the dominant and servient party, what was the opportunity, how much opportunity to influence did the dominant party have, was there a failure to include parties in the will who otherwise would have been expected to benefit? In other words, did the person try to write their spouse out of the will? Did they try to write their kids out of the will? That would at least draw some suspicion and make a court try to analyze, what's going on here. And then the extent to which the will is different from and purports to revoke a prior will. So if you find that, a person is, well into their 80s or 90s, and for years they've had this one will in effect, and then, on their 95th birthday, right before they die, they come out with this new will that completely revokes the old one, writes all their kids out of the will, writes their spouse out, that's the kind of thing that would draw a lot of suspicion and make us wonder, was somebody unduly influencing the deceased? So that wraps up our chapter on mutual assent. I hope you all have a good one.